Following the court's rejection of the FCC's rules, the FCC began exploring other options. In May of 2014, the FCC issued a notice of proposed rulemaking to identify an avenue for its net neutrality rules that would survive legal challenge. The rulemaking process produced the order the FCC ultimately adopted on February 26th of 2015. The FCC accepted the Verizon Court's implicit invitation to reclassify broadband internet access services as telecommunication services. What the FCC claimed was that through this reclassification, the FCC avoided any limitations that past classification decisions placed on its ability to adopt strong net neutrality rules. In terms of substance, the order built upon but significantly expanded the 2010 Open Internet Order. Indeed, the chairman of the commission, Tom Wheeler, called the FCC's order, quote, more powerful and more expansive than any previously considered or suggested. First, the order prohibits blocking, stating that a person engaged in the provision of broadband internet access service, insofar as such person is so engaged, shall not block lawful content, applications, services, or non-harmful devices subject to reasonable network management. Second, the order creates a separate rule for degradation. Quote, a person engaged in the provision of broadband internet access service, insofar as such person is so engaged, shall not impair or degrade lawful internet traffic on the basis of internet content, application, or service, or use of a non-harmful device subject to reasonable network management. The 2015 order supplanted the previous anti-discrimination rule with two rules. First, the FCC adopted a rule on paid prioritization, saying that a person engaged in the provision of broadband internet access service, insofar as such person is so engaged, shall not engage in paid prioritization. Paid prioritization is defined as management of a broadband provider's network to directly or indirectly favor some traffic over other traffic. The limitation applies to prioritization for money or to benefit any affiliated entity. Second, the FCC adopted a rule that a provider cannot unreasonably interfere with or unreasonably disadvantage end users' ability to select, access, and use broadband internet access service or the lawful internet content, application, services, or devices of their choice, or edge providers' ability to make lawful content, applications, services, or devices available to end users. The FCC's February 2015 order already faces several significant legal challenges. The arguments in these challenges have not been fully developed, but plaintiffs are likely to claim that the FCC improperly classified internet access providers as telecommunications providers. Relatedly, the core prohibition in Title II of the Communications Act is on unjust and unreasonable discrimination. If that provision has historically been understood to permit carriers to charge different prices for different services, can it provide the basis for sustaining FCC rules that make that practice unlawful in the broadband internet access context? Beyond these questions of statutory authority, are the FCC's network neutrality mandates sound as a matter of policy? In other words, is government regulation of internet access providers necessary to ensure that providers do not improperly block or degrade lawful content, or to ensure that providers do not prefer certain content? As you consider this policy question, where does wireless come into play? Much of the narrative offered by supporters of network neutrality focuses on fixed broadband providers. In part, the claim is that large internet access providers, such as cable companies, will use their market power to favor particular content providers, particularly those affiliated with them. But some argue that the rise of broadband mobile providers injects much more competition into the market for internet access, thereby undermining the claim that government regulation is necessary to eliminate a threat to internet freedom posed by cable companies and other fixed broadband providers. In other words, some would argue that a critical aspect of the debate over network neutrality is whether and how the growth in mobile broadband changes the broadband market, perhaps undermining the basis for some of the FCC's recent rules. Whatever effect the growth in the mobile industry might have on the general basis for the FCC's order, Another critical question is how the order itself applies to mobile broadband providers. Here, the FCC's February 26, 2015 order reflects a marked departure from all prior network neutrality initiatives. The 2010 Open Internet Order, for example, treated fixed and mobile broadband providers differently. The FCC there concluded that mobile broadband presents special considerations, in part because it was an earlier stage platform than fixed broadband and is rapidly evolving. So the 2010 order imposed a narrower no blocking rule on mobile providers than on other providers. In addition, the no discrimination rule, stating that providers may not unreasonably discriminate in transmitting lawful traffic, applied only to fixed broadband providers. The 2015 order breaks from this approach and specifically applies the Open Internet rules to both fixed and mobile broadband internet access service. The order does carry forward the concept of exceptions for reasonable network management, and it acknowledges that the reasonable network management practices of a mobile provider may differ from the practices of a fixed provider. In addition to reclassing fixed broadband providers as telecommunications services, the 2015 order reclassified mobile broadband internet access in a manner that permitted common carrier regulation under Title II of the Communications Act. The impetus for the FCC's shift toward mobile broadband providers lies once again in the massive growth of the mobile industry. Consider FCC Chairman Tom Wheeler's statement on mobile internet access. Quote, "For the first time, those ground rules will apply both to wired and wireless access to the network. Mobile networks account for the vast majority of internet access. Mobile is a critical pathway and it must be open and fair." Dissenting Commissioner Michael Riley accused the FCC of ignoring, quote, "fundamental differences between wireless and fixed broadband industries and technologies." He claimed that competition in the wireless industry has yielded unparalleled investment and innovation. Quote, "Applying a regulatory regime established from monopoly voice service to the dynamic mobile sector defies logic." He accused the Commission of flagrantly ignoring the fundamental technical and operational requirements necessary for mobile broadband networks. And he said that unlike fixed systems, mobile network capacity is constrained by the relative scarcity of spectrum resources. Given this unique limitation, wireless providers must maintain their ability to vigorously and nimbly mitigate the congestion inherent in wireless networks. I expect the rigid Title II rules adopted today will hamstring the smooth functioning of these networks. Whether the FCC's net neutrality order will survive the legal challenges that have already been filed remains to be seen. Those challenges are likely to take years to resolve. However the courts resolve the core questions of the FCC's authority, the critical policy questions will remain. As a matter of engineering, do net neutrality rules make sense? Will net neutrality rules promote or stifle innovation? Do market changes engendered by the wireless explosion render government intervention unnecessary? And does the wholesale extension of net neutrality rules to mobile broadband services provide an even greater threat to innovation than in the case of fixed broadband services?